Hi, for those of you who don't know who I am, my name's Elizabeth Moroney. I'm head of the antitrust litigation practice at Clifford Chance, and I am here merely to welcome you today to the 8th David Vaughan lecture on antitrust litigation. I'm going to hand over to James, who's going to introduce Sir Marcus Smith to you. But I did want to thank you all for coming, not least because we obviously haven't had this lecture for 2 years now because of COVID. We did, Paul and I should say thank you to Paul, who puts a huge amount of effort into arranging this. Paul and I had a number of conversations about the pros and cons of doing it online during COVID, when that was obviously the norm. But we decided that we didn't think David would really have understood that, might be the word. And I asked Leslie before, who thought that was probably right. But I think although he might have been intrigued by the concept and the ability to do those things online, I think it wouldn't have allowed sufficient opportunity to talk to people and possibly be a little bit entertaining if he were here, which is what David was so good at combining. So I'm pleased that we didn't do it, and I'm pleased that we're all here in person. I hope David is too. And I'm going to hand over to James to introduce Sir Marcus. Forgive us for moving microphones.
Right. In a very high-tech way, I will try and clip this on. And much of what I was going to say by way of introduction, I see is on the sheet, which is in front of me. So my research went a little bit into introducing our speaker. His who's who recreations are writing and Norfolk. You may need to explain that, Marcus. And being an assiduous researcher, I went a little bit further and issued a request for further information to someone who will remain anonymous in Fountain Court, the chambers from which Sir Marcus practiced for many years before going onto the bench, and indeed Weil, who was the chairman of the Appeal Tribunal from 2009. So I issued my request for information, and it came back saying, well, I'm a bit busy at the moment. I'm afraid I don't think I'll have much to go on. When I was his best man, he seemed to have lived such a blameless life that I had very little to go on at the time. So Marcus will know who I asked, and I shan't say any more than that. So rather than the details, sort of a bit of character. I think what we have in Sir Marcus is a judge with an academic bent. He still is, I think, or at least was recently, editing and writing leading textbooks on reinsurance and assignment, which I did not read by way of preparation for this short address. And as those who've appeared in front of it, and that probably includes very many people in this room, the competition big community being quite a tight one, will know that he's above all an engaged judge. He's an innovative president of the tribunal, and he loves trials. He loves the details. He loves the law. He loves engaging in dialogue with the advocates. And also the witnesses. He's right into the details. He works very hard, and he is fundamentally fascinated by the principles that he is charged with applying, all of which means that I think we have much to look forward to when finding out what has struck him in thinking about this title, which he's actually had 2 years to think about because of postponements of this lecture, as been mentioned. So it's my great pleasure to introduce Mr. Justice Marcus Smith to address us on adjudicating competition questions, markets, competition, and the law.
Let me see. Give this a go. Right. Excuse me while I just get the technology. Right. dear. Let's try. Right, that's the wrong way around. I think we're there. Can you hear me? Thank you very much for that very kind and generous introduction. You're right, I have had 2 years to think about this. And when I looked at my notes a couple of weeks ago, I thought, I'm going to have to cut this back because I can't keep you here all night. So just to ensure that you're happy with what I'm going to say, I'm going to start my stopwatch and try and make sure that I don't go too far beyond the 3 hours that I've been allocated. It's often the case that we are presented with the fruits of what is called an evidence-based inquiry. Indeed, evidence-based practice seems to have taken over decision-making in many areas, including, I looked at their website, the Chartered Society of Psychotherapy. Now, they define this approach in the following rather circular terms. Evidence-based practice, they give it an acronym, EBP, requires that decisions about healthcare are based on the best available current, valid, and relevant evidence. So evidence-based practice is based on evidence, as long as it's current, valid, and relevant. Well, I'm glad we cleared that up. The problems that we have in the practice of modern courts, and I'm including in particular the courts operating out of the Rolls building and the tribunal that I'm privileged to lead, the Competition Appeal Tribunal, adopt a rather similar approach to the Chartered Society of Physiotherapy, in that we've moved away from rules of admissibility. It's rather rare for us to say that something is inadmissible. Instead, we say, as I've done many times myself, that we say this goes to weight, not admissibility. And in doing so, we have in effect abandoned the law of evidence, whose purpose it is, as Phipson tells us, to lay down rules as to what matter is or is not admissible for the purpose of establishing facts in dispute. In other words, the role of the law of evidence, strictly understood, is to define that material which we can and cannot admit in order to prove a certain fact. Now, evidence is not something like the law of physics, like gravity, something which exists unchangeably and which we are trying to understand. Evidence is what we choose it to mean, or more precisely, what the law defines it to be. A time was when identification evidence was needed to be corroborated, and if not corroborated, was excluded, and not merely the subject of a warning as to weight, as it is now. Longer ago still, the evidential rules for testing for witchcraft were at the same time both clear and arbitrary. The swimming test, if you floated, you were, if you sank, you weren't, had all the disbenefits of arbitrariness and irrationality, but they were at least clear as a means of proving or disproving the fact in issue. Now, I'm not here to advocate for a return to the past or back to the future. Strict rules of evidence have a tendency, it's inevitable, to exclude material that is probative, and that is a bad thing. Anyone who sat through all 8 of Colin Tapper's lectures on the law of hearsay, as I did in the late 1980s, will appreciate how quickly technicality in relation to abstruse points of law can accrete to the benefit of none. But what I am going to say is that the nature of antitrust litigation, and it may be market litigation more generally, renders an understanding of the purposes of the evidence that we seek to induce increasingly important. Even if we stick to the mantra that weight, not admissibility, is what matters, we've got to be increasingly clear about why it is that certain evidence is being imported into the courts and what purpose it serves. So in a sense, if one abandons rules as to admissibility in the strict sense and moves towards weight, we have to ask ourselves, what is the purpose of the evidence that we are seeking to adduce? So I'm going to address a number of issues which concern or arise out of the evidence in competition claims and which make their adjudication and management both interesting and tricky. The first issue that I'm going to address is the problem of multiple similar claims. Now, in competition cases, and it is, I think, a peculiarity of competition cases, the same facts give rise to multiple claims. So the cartel that fixes the price of widgets gives rise to a potential cause of action vesting in each purchaser of the overpriced widget. Indeed, as we all know, the story doesn't end there. If the purchaser of the widget is not the ultimate consumer, but someone who uses the widget as a component in order to make blodgets and increases the price of blodgets accordingly, why then an indirect claim is generated, vesting in each person who has been indirectly overcharged. And so the circle of potential claimants expands, and particularly with the advent of collective actions, will expand quite dramatically. Now, aside from questions of causation, loss, and damage, where, generally speaking, and subject to certain qualifications, the loss is individual, these claims will bear a remarkable similarity to each other, particularly when considering questions of infringement. Now, of course, these claims will be legally similar, but I'm not very worried about that. We have a doctrine of precedent, and over time, law that is unclear or uncertain becomes clear and certain, or at least clearer and a bit more certain, depending on how optimistic one is about the appellate courts. The problem exists in relation to questions of fact. The facts relating to one market abuse, one competition infringement, will generate multiple causes of action. Yet the findings in one case will not bind the tribunal hearing later cases. That is right, because there is no identity of parties, and so no room for res judicata or issue estoppel. It may be that there is a lead case approach that can be adopted, along the lines of Ashmore against British Coal Corporation. In Ashmore, 14 sample cases proceeded to trial out of some 1,500 claims under the Equal Pay Act 1970. When the representative sample was selected before the Industrial Tribunal, it was actually agreed that the decisions in any of the sample claims would not be binding upon the applicants or the respondents in any of the non-selected claims, although, of course, it was hoped that the decisions would assist in the resolution of those later claims. The 14 sample claims were dismissed after hearing before the IT, and there were subsequent appeals by the employees, which were unsuccessful. Mrs. Ashmore was not one of the claims that was going on. Mrs. Ashmore brought her claim separately and later. Her claim had been stayed pending the determination of the sample claims. And when she brought her claim, her employers sought to strike it out and successfully obtained a strikeout order on the basis that it was an abusive process to seek to relitigate issues determined in the sample claims. And Mrs. Ashmore's appeal to the Court of Appeal was refused on those grounds. Now, the critical factor in Mrs. Ashmore's case was simply this. It was seen as a failed attempt at relitigation of a claim that was so completely similar to the earlier claims that had failed that it would be something bringing the law into disrepute if one allowed a later claim to succeed where the prior claims had failed. So Ashmore is a useful authority in the procedural armory where one has multiple separate cases not covered by res judicata and issue estoppel. But I fear that it will not be sufficient to resolve the concerns that I have out of multiple cases arising in the competition sphere. And that is because the concerns that I have already manifested themselves. Whilst it is quite self-evidently wrong for very similar background facts to give rise to radically different outcomes where the same competition infringement is alleged, that is exactly what happened at first instance in the MasterCard Visa MIF litigation. This litigation, having featured at first instance before the CAT, before Mr. Justice Popplewell and Mr. Justice Phillips, as they then were, went up to the Court of Appeal and then to the Supreme Court, where they were then remitted back to the CAT and now fortunately have settled. I'm not so much interested in the subsequent procedural history, but I am interested in the events that occurred at first instance. Now, all three cases concerned a claim that MasterCard and or Visa had infringed competition law in establishing and implementing certain fees known as MIFs, multilateral interchange fees. The first case concerned a claim by Sainsbury's against MasterCard, with Sainsbury's alleging that the fees it required to pay on debit and credit card transactions under MasterCard's scheme were in violation of competition law. This was one of those cases where there was no mystery about the allegedly infringing arrangement, which was there for all to see in the contractual documentation. The tribunal, and I should declare an interest here, for I was one of its members, had to consider many issues, one of which was whether there was an infringement by effect. In doing so, we carried out the traditional analysis of identifying the allegedly infringing provision, obvious here, and trying to work out what its harmful effects were by reference to what the position would have been in the absence of the allegedly infringing agreement or provision. In other words, we carried out a counterfactual analysis. In later cases, this counterfactual analysis was somewhat dubiously characterized as a question of fact, and that is a point I will be returning to. At the moment, I'm considering how common factual questions, not necessarily counterfactual ones, can result in different outcomes. Our conclusion in Sainsbury's, based upon the somewhat limited evidence before us, was that in the counterfactual world, the MIF would have been replaced by bilateral interchange fees negotiated between each participating bank and MasterCard. This, we also concluded, would result in a better market in terms of outcome for reasons that we articulated. Come the next case, tried in the commercial for Mr. Justice Popplewell, MasterCard had changed the evidence that was before the court. Mr. Justice Popplewell was invited to follow or read across previous decisions of the EU Commission, and he declined to do so for reasons which, I may respectfully say so, are unimpeachable. Of course, what's sauce for the goose is sauce for the gander, and Mr. Justice Popplewell took exactly the same approach in relation to the decision of the tribunal in Sainsbury's. What he said was this. There is also, of course, a very substantial overlap between the factual issues decided by the CAT and those I have to decide. Here, too, I'm not bound by the findings, although the parties agreed I should take them into account and give them such weight as I thought appropriate. It is important to keep in mind in this context that the evidence before me was not the same as that before the CAT in important respects. For example, the CAT bilateral's counterfactual, which is at the heart of the CAT's conclusion, was a construct of the tribunal itself. It had not been addressed in the witness statements or experts' reports of either party. It had not been put to factual witnesses. By contrast, the parties put before me detailed factual and expert evidence on the point, tailored specifically to the findings and reasoning in the CAT judgment, which was all to the effect that such bilaterals were unrealistic. Now, with one qualification, I entirely agree with what he there said. You've got different factual evidence before you. A judge is obliged to decide the case on those facts and not on other facts, which were before another tribunal. That is entirely right, and in essence is the problem that I'm articulating. I will push back in one respect. Although I think it is fair to say that the bilateral's counterfactual was a construct of the tribunal, it was put to the witnesses and the parties, as the judgment makes clear. It's not something which either party particularly contended for. I'll come back to that in a moment as well. But it was, we considered, open to us on the evidence. The problem was that the evidence shifted entirely, understandably, between the first trial and the second. Now, what this passage does is it highlights the very considerable difficulties that arise in litigating market-wide issues in sequential party against party cases. And the fact is, we are going to have to try to find a way of resolving market-wide issues consistently between cases, but in a manner that is also fair to the individual litigants. Now, I'm pleased to say we've made a great deal of progress in this regard, although a great deal remains to be done. The first step in ensuring consistency is to house all these claims in a single jurisdiction under one roof, as it were. The Court of Appeal, in the MIF appeal, which considered all three of the interchange fee appeals, made clear that similar cases falling within its jurisdiction should be transferred to the tribunal. And that has now happened. The Rolls building has done a clear out of common cases. And the CAT now has a fine collection running into the thousands of interchange fee and trucks cases. Indeed, I think it's hard not to recall the look of glee that was on the face of both the Chancellor and Sarah Cochrane, the judge in charge of the commercial court, when I said, "Bring me your myths and trucks cases." They said, "Yes, we'll get them. Anything that you want, you can have." And that is a process that has continued. It's a sign of the cooperation that exists between the various different tribunals handling competition work. And it stands, I think, in stark contrast to the experience in other jurisdictions where, for example, trucks cases are tying up an awful lot of the business of courts in, for instance, Spain and other jurisdictions, where what's happening is the other business courts is being pushed out to the disadvantage of other litigants. So housing claims under the same jurisdictional roof is obviously a good idea, but it is only a first step. It doesn't actually solve the problem. It merely transfers it to a single jurisdiction where it can be handled further. So in short, what this approach does is it creates the potential for resolving similar issues in similar proceedings in the same, or at least not inconsistent way. And the next question is how that potential can be achieved. Now, it may be that Ashmore and sampling will be a tool that we can deploy successfully, but it may well be that an issue-based approach involving all parties in all relevant claims is the answer. Frankly, we don't know. That's a matter for case management going forward. But my hunch is that sampling isn't really going to work. There's too much potential for different parties to take entirely proper different points and so result in different outcomes unless you've got the same tribunal hearing the same issue at the same time on the same evidence. Now, tribunal aficionados will have clocked the tribunal's practice direction 2/2022 on umbrella proceedings, where Rule 17 of the Tribunal Rules 2015 has been pressed into service so as to enable an issue in one case to be plucked out and heard, if appropriate, by another tribunal that has similar issues before it. So in effect, one has an ability to transport a single issue or issues out of one case and into another case. Now, we're in the early stages of seeing whether umbrella proceedings can do what we would like them to do, to resolve in a single forum multiple similar issues. It would, however, be dangerous to underestimate the procedural and logistical difficulties that arise. Simply the volume of these cases in terms of administrative burden is enormous. I mean, the process administratively of closing the books in the Rolls building, shutting up the account and saying this case is now off to the cat, starting the same case files in the cat is an administrative burden that parties don't see, but is a real problem. You've equally got problems about the differences in the rules between, for instance, amendment of claim forms prior to service, where the CAT has slightly different rules to the High Court parties, and these need to be assimilated and dealt with. So it's by no means a seamless process. But we are, I think, at least in a position now where we can discern some positive effects, and hopefully those positive effects will be magnified and increased as time goes by. One instance, though, of one positive effect is this. Many claims seek a stay of proceedings, and in the past, the stay would be granted without any particular terms being imposed. That's now changed. We are, as a tribunal, very happy to grant a stay in general, but it's on terms. First of all, an undertaking is extracted that whatever happens in the proceedings binds the party to the stayed proceedings as long as it remains a common issue. So you can go to the back of the queue, but whatever happens before your case comes on binds you. Secondly, we have created an exposure to the need to give disclosure. So should that be ordered, your stay will not save you from saying no disclosure. So what happens is you go to the back of the queue if you want to, but unlike Mrs. Ashmore, you can't relitigate. And the evidence in the stay case, if relevant, will be available to the other parties, subject always to judicial control. So long story short, This is, I believe, an instance where we can, with careful case management, have our cake and eat it, in that we can decide individual cases individually, yet also consistently. And we do so by ensuring that evidence in different cases is heard and considered across and in different cases where common issues exist. So this is the first instance where a real control over evidence is required in order to achieve both a just result in the individual case and a consistent result across individual cases. They're both important principles of justice. It's important to have them both in mind. And hitherto, the emphasis has been too much on the individual case, because normally individual cases are different, and not enough has been thought about the fact that it is the same act in competition cases that creates all these multiple claims. So my first topic has thus been concerned perhaps less with the law of evidence and more with ensuring that the same evidence is heard in similar cases by the same tribunal, much more to do with case management than strict evidence. My next topic concerns the good old counterfactual question that is so common in competition law analysis. It's called counterfactual for a reason. It involves an analysis that is contrary to the facts as they stand. In many cases, and I'm certainly not trying to be exhaustive here, it involves imagining what the market would have been like absent the infringing agreement or provision or act. The question that I'm going to ask is the extent to which this is entirely a factual question. Now, to wind back a little bit, counterfactual questions arise in every claim for damages, for breach of contract, or where tort has been committed. We shouldn't make the error to think that the counterfactual analysis is something that's been dreamed up by clever competition lawyers. It's a counterfactual approach that has been extant for many, many decades. So in a breach of contract or tortious claim, the court's duty is to put the claimant in the position they would have been in had the contract been minimally complied with, or had the tortious act or omission never taken place. And although not expressed as counterfactuals, these questions are precisely that. Take the person injured by another's tort, such that they can never work again. The actuarial tables will be consulted to see how long they would have lived, but for the accident. Evidence will be adduced to show what that person's career structure would have been, so that the loss of earnings, as one of many heads of damage, can be assessed over a defined period of time. Now, these are difficult questions of factual judgment, but done by our courts every day of the week. To what extent are the questions that arise in a competition case different, if at all? I think they are different in a number of respects, but one particular respect that I'm going to come to is what I'm going to call a normative element. But before I come to the normative element, I'm not sure about the label, but it's the best I could come up with. Before I come up with the normative element, there are a few points of more general application that I ought to make. First, entirely unsurprisingly in the competition context, the evidence of expert economists is of cardinal importance before the tribunal, reflected in the fact that to enable proper evaluation of that evidence, the panels of the tribunal comprise an economist. Economic or econometric evidence is common, and we are beginning to see the deployment of behavioral economists and game theorists. That is all grist to the mill. If it is of assistance and is genuine opinion evidence, why then we'll admit it. Now, economic evidence is evidence of a very different quality to that admitted in other disputes. But the fact is that an analysis of markets involves an altogether broader brush than the resolution of a bilateral dispute in another court between A and B. So that is the first general point that I would want to make about competition litigation and the counterfactual. Secondly, and in contradistinction to my first point, economic evidence is not the be-all and end-all, and there are limits to the extent to which economists can assist in understanding an industry. Economists are not industry experts. No matter how eminent, an economist cannot tell us, or if they do, it is not proper opinion evidence, how deep-sea cables are laid or how credit card transactions actually work. We must beware of overreach in terms of how parties deploy their economists, and the parties must be aware of the limits as well as the strengths of this sort of evidence. So that is a warning against over-reliance on economists. Thirdly, where we are presented with rival expert opinion, the tribunal may very well prefer one view over another and adopt it wholesale. We hear two experts who prefer A to B or B to A. That, however, in my experience, is the exception rather than the rule, and it is certainly possible for the tribunal to adopt a magpie-like approach and select the nice shiny bits from each expert's evidence, and so reach a conclusion that neither expert has necessarily contended for. That is an approach which I find is taken quite often in competition cases. One hears the evidence, one decides the triangulated course that is the best answer to the case. The submission that an expert's work cannot critically be reworked by the tribunal is one that crops up quite often in competition cases, and it seems to me is something that needs to be rejected for the reasons given by the tribunal in Cardiff Bus. In that case, we had the typical two views of the experts, and there were good bits in each. And what we said about the good bits in each was this. We said, Mr. Good and Dr. Niels, two experts, sought to assist the tribunal in what sort of revenue would have accrued to travel had the infringement not taken place. We have found their work extremely helpful, we said, and have taken it fully into account, but we certainly do not consider that the opinion evidence in their reports must be used on a take-it-or-leave-it basis. It is for the tribunal, based upon the factual evidence, to make an assessment of what would have happened in the counterfactual scenario, and this may very well involve reworking calculations done by the experts or adopting an approach which, although it draws on the work of both experts, adopts neither approach completely. That is what has occurred in this case. Our approach is neither that of Mr. Good nor that of Dr. Niels, but based upon the factual evidence we have heard, represents our concluded view as to what would have occurred in the counterfactual scenario. This third point is one which crops up more often in the case of economic evidence than in other types of evidence. The fact is that economists need to apply their judgment across a range of questions where the factual underpinning is both fluid and open-textured in terms of what is or may be relevant. In other words, the range of reasonable opinion in economic judgment is far wider than arises in, say, the expert engineer who explains how an oil valve works, or the expert software designer who explains a particular piece of computer functionality. In other words, the element of judgment and the range of reasonable opinion is far wider in the context of economic evidence than it is in the context of other expert evidence. To put it more cruelly, and it is one of my favorite jokes, and I hope any economists in the room will forgive me, economists were put on earth to make astrologers look good. Now, these issues of assessment of evidence are, I think, general, although competition cases may involve these points emerging with a particularly hard edge. But I also said that competition cases involve a normative element, which I do think is specific to competition law. When rejecting the tribunal's bilateral analysis in Sainsbury's, Mr. Justice Popplewell said, I think this was a criticism, that the bilateral's counterfactual, which was rightly said to be at the heart of the Cat's conclusion, was a construct of the tribunal itself. As I've said, I disagree with that at least in part, in that the point was evidentially based on material before the tribunal, albeit that material was in different form before Mr. Justice Popplewell, hence his different finding. It is right to say that that approach was not advocated by either party. It was simply a reflection of the magpie approach I've already described. As I've said, I do not consider that a court is required to choose between two arguments advanced by the experts without considering the alternatives justified by the expert evidence in the teeth of what the experts were contending as their opinion. Not to be critically evaluative of the expert's view is in itself an abdication of judicial responsibility. And in Sainsbury, we considered very carefully Dr. Niels's reasons why there would be no bilateral interchange fees, found those reasons wanting, and rejected them. More to the point, when assessing counterfactuals where a market is involved, it is necessary to bear in mind that markets contain this normative element, and it's a mistake to consider that markets exist as somehow an inherent thing or are natural or self-evident. Let me try and unpack that a little bit and explain what I mean by the normative element. Markets are, I would suggest, completely unlike actuarial tables used in the assessment of the quantum of PI claims. The outcome in the PI claim is informed by actuarial tables which are governed by the laws of statistics. A claimant cannot choose to have a greater life expectancy than the expectancy predicted by the tables, save to the extent that there is a material variable not catered for in those tables. Nor can a judge properly make such a finding inconsistently with what the evidence says. The position in a markets case is, I would suggest, very different. The problem is that people speak of a free market as if the more deregulated a market, the better and the more competitive it is. And that, if I may say so, is nonsense. The most efficient markets, in terms of articulating price by the interaction of supply and demand, are actually the most regulated. I'm talking about exchanges. It's interesting that in his description of the market, Marshall had primary recourse to exchanges as good examples of working or competitive markets. The point about exchanges is that the variables in the contracts for buying and selling whatever the product is are highly limited. Essentially, they're limited to quantity or volume, price, and time for delivery. The product itself, whether it is a share or a ton of copper or whatever, is fungible, it's standardized. Now, this limitation on what you're transacting means that the forces of supply and demand are given free rein, and pricing through the interaction of supply and demand is more accurate. Not of what the price should be, but of what the markets actually think the price is, which at the end of the day is the essence of a free market. The point about exchanges and free markets in that sense is that exchanges do not arise out of nowhere, nor do the rules for auctions or quasi-exchanges like the FX markets. Markets are made, whether by accident or design, and are neither inherent nor inevitable. They are sculpted by their legal underpinning, which can be various and can be good or bad. If we take the view that markets are what we make them, then when considering them in their operation in the real world, and when considering the counterfactual scenarios that arise in any given case, then we need to understand and explain the market structures present before we can ever get to such things like market definition. By understanding how markets work, I include what they are intended to achieve, and that is what I'm calling the normative element. Now, granted, this point about market design is swept up and conflated with market definition. And that is an exercise that we all undertake in competition cases from time to time. My suggestion is that market operation, what the market is trying to achieve, and the rules that enhance and constrain it, need to be carefully borne in mind. Alvin Roth, an American professor, has written books on the designing of markets. In his introductory chapter in one of his books, Roth makes the critical point that markets are not about the price. That's an important element, but only an optional element that not all markets have. But it's about matching supply and demand, meeting need. He describes markets, for instance, donor markets, which operate not on money or conventional supply and demand, but on matching donors of kidneys, for example, to those who have the need. He makes the important point that even altruism requires structure if it is to work efficiently. Now, normally, we are concerned with markets that involve price, and price is the intermediator between supply and demand. But increasingly, when one looks at the technical platforms that exist, things like Google and Facebook, one is seeing products that are actually being offered ostensibly for free. And that is something which we need to understand. We need to bottom out before we ever get to articulating what the market is by way of definition, what the alternative products are, and what, in the end of the day, the competition infringement is or is not. So design really matters. And what Roth says about this is really important, and I'll quote something from his first chapter along these lines. Sometimes, he says, a matching process, whether formal or ad hoc, evolves over time. But sometimes, especially recently, with design. The new economics of market design brings science to matchmaking and to markets generally. That's what this book is about. Along with a handful of colleagues around the world, I've helped create the new discipline of market design. Market design helps solve problems that existing marketplaces haven't been able to solve naturally. Our work gives us new insights into what really makes free markets, he puts that in quotes, free to work properly. Most markets and marketplaces operate in the substantial space between Adam Smith's invisible hand and Chairman Mao's 5-year plans. Markets differ from central planning because no one but the participants themselves determines who gets what. And marketplaces differ from anything goes, laissez-faire, because participants enter the marketplace knowing that it has rules. In short, market's definition, and I'm not in any way denigrating what is an important tool, perhaps needs to be preceded by an understanding of market design, to co-opt Roth's term, or the true environment in which a market operates, in fact. And that requires evidence from those who know how the market works, or how it should work, which will probably not, to go back to one of my earlier points, will probably not be evidence from an economist in the first instance, although economic evidence will generally be a critical analytical tool in the later stages of the inquiry. Put another way, a counterfactual question does not simply involve asking how would this market be if the infringement was not occurring, but also how should this market be if the infringement was not occurring. Focusing only on the first question implies that if the infringement were removed, there is only one possible counterfactual outcome, and that is something that I would question as a suggestion. The reason I question it is because it's a reflection of what I would consider to be the erroneous notion that the market is a single construct or an interface that is in some way fixed and inevitable in its form. I don't think markets are that way inclined. They are much more subjective and much more rules-based than that. You'll be relieved to hear that I'm moving on to my final point. I'll just check how I'm doing on timing. 37 minutes, looks good. So my final point is going to be a relatively quick one. And it's this. It's a quick point because it requires a degree of unpacking and discussion, which is a matter for another time and not today. So I float it rather tentatively. Anyone who's done a competition case is likely to have buried somewhere around page 206 of some expert report a diagram with solid lines representing the supply and demand curves for a given product. Supply and demand schedules, as Keynes would have called them. Almost never will the evidence support an unbroken supply or demand curve. The data simply won't exist. The difficulty of obtaining this data is made very clear in another book I'm going to quote from, Economics for Competition Lawyers. What they say is this: a lot of the time that economists spend working on competition cases actually involves trying to locate this demand curve. They need this, for example, to delineate the relevant market, to measure market power, or simulate the price effect of a merger. Economists can normally observe only one price quantity point in the field, which is the current price and quantity. If they are lucky, they can observe a few more points. For example, if the price has changed from last year and a different quantity was sold at that price. Even then, quantity changes may be due to factors other than price changes. But it is never possible to see the full relationship between price and quantity. Economists have to assess empirically the properties of demand in the vicinity of the price quantity points they can observe. They will in particular want to know how sensitive demand is to price. This, it seems to me, is a really important point for courts. The true nature of the demand and supply curve in relation to a given product or a given industry is hugely difficult to identify. You can't simply present an unbroken line and say this is the demand schedule for this particular product, because you just don't know. It's very important to understand that that is evidence that you are not going to have, except in a much more attenuated sense. A great deal of the material that comes before the cat has the flavour of material that would not be given the time of day in other courts. I'm not thinking so much of expert evidence, but for example, of the surveys and questionnaires describing consumer preferences that have been served up to me in more than one price control appeal that I care to remember. And I say that with no disrespect to those doing the serving up. The fact that such material is adduced is a sign of the paucity of data that will exist in many competition and market disputes. Evidence, as I've already said, is a pretty eclectic concept in competition cases. That is because the traditional rules of evidence, even if these days they are not exclusionary but go only to weight, are singularly unsuited to the sort of issues that come up in competition and market cases. We have to deal with statistical evidence and econometrics, artificial intelligence and its use in the review of mass data. It's a matter for separate and careful consideration just how the courts should deal with market or economic evidence like this. Since you can't really prove very much of the demand curve, to take an example, with empirical evidence that lawyers are used to, it's pretty important that lawyers, and judges in particular, begin to get their thinking caps on as to how this sort of evidence is to be marshalled and controlled, and these issues proved. Ought we to have some form of the laws of economics that sets out how the tribunal is going to approach certain questions, so that the parties coming before it know that they're going to have to adduce evidence that disputes it? For example, we could have a rule of thumb that unless evidence is adduced to the contrary, the tribunal will say this: we will proceed on the basis that the demand curve, as is normal, slopes downwards left to right, and the supply curve does the opposite. Now, I say this not to constrain the parties, but to encourage them to invalidate the proposition so advanced if they choose to do so. I'm really taking a leaf out of Karl Popper's falsification theory. The philosopher Popper suggested an approach called negative verification or falsification. Under negative verification, tests would be conducted with the express purpose of failing, thereby disproving a theory. It seems to me that if we start articulating the general rules by which the tribunal will presume to resolve economic theory, we set up a target, not a straw man, but a target which will enable our economists to take aim at something and to say, well, this may be the general position, but here you're wrong, the general proposition does not apply, here's the evidence showing why it does. In other words, we don't go in with a blank sheet of paper, but we go in with an understanding of what is the default to be disproved as appropriate. Now, I raise that very tentatively, and I would be very interested in what views exist from this audience. I want to end by saying something about David Vaughan. I only knew David by his reputation, and to adopt the happy phrase of David Anderson in his tribute to David, I also think I know him through the future, as they were then, judicial talents he attracted to Brick Court, people like David Lloyd-Jones, Gerald Barling, and Nicholas Green, to name but three. And what a reputation it was and is. I think he would have liked the present state of play. Competition law, in all kinds of surprising ways, has reverted to something a bit like the Wild West, as it was when David first turned it into a proper practitioner subject, with digital markets, two-sided markets, and an increased recognition that competition really matters to the consumer. The evidence that we hear is critical to shedding a light on these important subjects, and for that reason I make no apology for having addressed adjectival and not substantive law tonight. But I want to end with words drawn, with permission, from David Anderson's moving tribute to David at his memorial service. And he said this: I don't know whether Vaughan, the young cavalry officer, had the same qualities as Vaughan QC. If so, we must imagine him not in an immaculately drilled squadron, manoeuvring on the plain, but on a daring mountain raid, with his band of irregulars, approaching at a wild gallop, gleefully scattering his enemies, and then feasting with much merriment by the fire. Well, I like to think that that may be what competition law is facing today. I'd like to thank Clifford Chance and Brick Court for arranging tonight and inviting me to speak. I'd like to thank you all for your kind attention. If there is any time for any questions, I will gladly take them.